just happened that. And then one last question, Nikki. I am happy to 100% take over and manage questions. Did you want to collect questions and ask them at the end of each session? Every partner I do this with is a little bit different.
Yeah, I mean, if you're wanting to do that, you can. I can also help out if you need any.
Okay, I will keep an eye on things. But if I miss anything, interrupt me, let me know.
I will.
Are you gonna do an introduction, or do you want me to start when it seems like we don't have any more people joining?
I think maybe a few more minutes. We usually have a bit of trickle in um, for a couple minutes after the hour. Someone asked if we would be sharing the slides after this.
Yes. So whoever registered, I will share the slides with you, Nikki, and you can send them to the emails that registered.
Perfect. I will do that.
And then I usually include, I can explain all of this once we officially start, actually. Anyone.
we can probably start now if you want. People will probably still trickle in, but I'll keep letting them in.
Okay. All right, everybody. We are recording, so just to let everybody know, the recording should be mostly the screen share and maybe my video. But if you want to make sure that your video is not recorded, feel free to turn your video off. And if you are able to, it would be great if everyone can mute themselves until they have a question, just so that we can avoid background noise where possible. I want to first introduce myself. I am Destiny Little. I direct the estate planning project. I'll talk a little bit more about the Legal Services Center, but we've done this partnership with the Boston Public Library for a few years now. And so I'm really excited that there was a bit of a pause that we've come back to do this and provide this for those who go to the Boston Public Library. I do want to share that the majority of what we're going to be talking about is very high level. I'm going to repeatedly throughout this say that some situations are really specific. And so I may get some questions in the chat. I'm going to monitor the chat. If you want to ask your question out loud for everybody, then if you know how to raise your hand, go ahead, or you can just interrupt me. But I prefer the chat. If you're able to type your question in the chat, you can send it to the full group chat, or you can just select my name on there, and it should just say send it to Destiny, in which case I'll be the only one that can see it, and I have the chat up. So I'm gonna move right along. You're welcome. Okay, so first off, we are not your lawyer, so today is just about providing community education. I'm not providing solicitation to enter into any sort of attorney-client relationship with you all. If, and this happens, if some of you become my client or our client down the road, there's going to be a formal written retainer that we both sign and agree to. But this is purely community education. And then also estate planning varies by law, or sorry, estate planning laws vary by state. The majority of what we talk about is going to be Massachusetts specific. There are a couple of areas where I'm going to be talking about federal law. So that includes all of the states and the territories of the United States. And I'll highlight when I talk about those. But unless I'm saying this applies to everybody in the United States, then assume that it only applies to Massachusetts. Estate planning is very, very state specific. You all will receive these slides. So if you registered for this program using a specific email address, that email address will later be sent all of these slides. I should have said that at the start. So don't feel like you have to frantically take notes. You're going to get all of these slides. You're going to see hyperlinks in these slides. They should work once you get them in your email. I'm going to take down a bunch of questions. For those that I can't answer today, I'm going to go back, do some research, and then I'm going to include some of those answers in the email that I sent to Nikki at the Boston Public Library, so she can share all of that with you. But a little bit about us. So the Legal Services Center, it's a nonprofit community-based teaching site. We are a nonprofit legal services center. We are a law firm, but similar to medical school, where the med students go out and become residents while they're in school, and they work with patients while working with full-on doctors. The law students at Harvard Law School work at the Legal Services Center along with other clinics to represent people before they go out and graduate from law school. So the majority of cases are run by law students. They are the primary advocate on the cases, and they're supervised by attorneys like myself. The estate planning project is one tiny piece of the Legal Services Center. So we handle a lot. We're 6 clinics. And one of the clinics is the Veterans Law and Disability Benefits Clinic. And one of the projects in that clinic is the estate planning project. So that just gives you a little bit of an idea of everything that we cover at the Legal Services Center. We are not located in Jamaica or in Cambridge. We are located in JP. We're the only Harvard clinic to not be located in Cambridge. It's very intentional. We wanted to be out in the community. And we're right next to Stony Brook Station off the Orange Line to make it easier for our clients to get to us. So the agenda for today, we're going to be covering financial issues during your lifetime, health and medical issues, and how to plan and prepare for death. If you have questions, again, please type them in the chat. I know new people are coming through. I prefer the chat. That would be great. If you can mute yourself, until you have a question. If you want to say it out loud for everybody, feel free. And we are recording this session. If you want to make sure that your video is not on the recording, go ahead and turn your video off. But it should just be, I think it should just mostly be me, since I'm going to be the one primarily talking. All right, so the first concept we're going to talk about that's going to really cover most of today is this concept of incapacity. And most people have heard of this concept of incapacity. It can mean a number of things, but it's really when a doctor determines that somebody is unable to communicate or understand concepts. And so they are determined to be incapacitated due to some type of medical disease. One example is if you need surgery, you're under anesthesia. When you're in surgery, you are unconscious, you're going through the surgery, you are incapacitated for the duration of that surgery until you wake up from anesthesia. You wake up from anesthesia, you may still feel a little bit drugged. You may still feel a little loopy. It doesn't mean you have full capacity as soon as you wake up. Once you can comprehend complex concepts in the way that you do on a daily basis now, and you understand the questions being asked of you, then you have full capacity again. So when we think of capacity, think of it in terms of this light switch. Sometimes it could wane and it turns off, and you may not have capacity, but then you can regain capacity. Some chronic conditions may severely or permanently impact your capacity, and it may worsen over time. Something like dementia or Alzheimer's are just a couple of those examples. So when we're talking about how these documents can help you, it's usually in terms of when you no longer have capacity and you need someone to step in and speak for you. We want to make sure that they are doing so in the right way and that they're doing so in a binding way where possible. So the first section that we're going to talk about are financial issues during your lifetime. And the first document is a document that most people have heard of. It's called the power of attorney. So in Massachusetts, this is, again, estate planning is very Massachusetts specific, it's state specific. So we're talking about powers of attorney related to Massachusetts and how we draft them here. In this document, you choose someone who's called an agent, or sometimes you may have heard of the term attorney in fact. I'm going to say agent because you don't have to be an attorney in order to be an agent in this document. So you choose someone to be your agent in the power of attorney document. The document itself lists out financial and legal decisions and authority that you want to give somebody else so that they can make those decisions and take those actions along with you. When they do it, it's not taking away from what you're doing for yourself. You're just assigning power that you already own to somebody else to help you out and work along with you if you need them to. In Massachusetts, you can name more than one person to serve at the same time. It is not recommended, but I wanted to say it so that everybody knows it is highly recommended that we just have one person serving at a time in this agency role. Also in Massachusetts, these documents can be as long or as short as we need them to be. You can have it so that the document itself only covers one specific legal or financial event, such as buying a house or selling a house. And then once that event is done, the document expires. Once a certain date is hit, the document expires. Most of the documents that we draft are called durable powers of attorney. That means that as soon as you sign it, it can be used. It's active. It doesn't have to be used. It doesn't mean that person now can go run amok and run along and go empty out your bank accounts. It just means it can be used if it's needed. And then it's durable, meaning it lasts through your incapacity. If you ever become incapacitated, this document can still be used. Without the durability clause, the language in this document, that means that if you were to become incapacitated, your agent could not use it anymore. So most attorneys draft what's called durable powers of attorney so that it really covers all those areas in your life where you might need somebody to step in for you and manage some things. If the authority is not written in the document in Massachusetts, they cannot do it. It's not enough to say, I give you full banking authority. You have to give them the authority to withdraw funds, to deposit funds, to check the balance of accounts. So some of these documents can get quite long and loaded with verbs because if it's not in there, they can't do it. So if you're working with an attorney to draft one of these, you want to make sure that the attorney is really explaining exactly what is in there and what's not in there. Because the assumption is if it's not in there, you never wanted them to do it in the first place. So they're going to ask you a ton of questions about your legal decisions that you make for yourself all of the time, the financial complexity of your current estate, just to make sure that you're assigning the right level of authority to help you out if you ever need it. And one last component that's important about powers of attorney in Massachusetts, we're going to talk a little bit about guardianships later on when we get into medical decisions, but this term of conservatorship, it's all within the same bucket. There are agents that are court appointed. So here we're talking about drafting documents and we name the agent in the document and we decide what they do. There are agents that are court appointed. Some of you may have heard of Britney Spears' conservatorship. It's made my job a lot easier when explaining this. So, for better or worse for Britney, that became a big thing. So people understand this idea of somebody being appointed by a court to manage something for you. A conservator, and I'll move on to the next slide here, is somebody who's appointed to manage affairs when somebody is wasting away their estate. A guardian, and again, there's a slide for it down the line. A guardian is for medical and healthcare decisions, those kinds of decisions that somebody makes in terms of their body and their day-to-day. If somebody says, so-and-so needs a guardian or so-and-so needs a conservator, and a court happens to agree, if you've named who that person is, and in this document, you're going to want to make sure that you're not saying, I think I need one, but if somebody ever says I do, then it needs to be this person. In the event that a court agrees, you need a court-appointed agent, a conservator or a guardian, and your power of attorney document names who you want. Absent good cause, which is a very high bar, absent good cause, the court has to appoint who you name in your document. So if this is all that you have in your power of attorney, it's worth it. You should name it because it makes sure that Joe Schmo on the sidewalk can't come in and claim a guardianship. There are some dramatizations around strangers coming in and taking over through conservatorships or guardianships, especially for people who are frail or older. It can happen. It doesn't happen nearly as often as like those TV shows lay out, but it can happen. But this is one of the ways that we can prevent that from happening. Any questions about a power of attorney before we move on? Okay. If something comes up, type it in the chat or interrupt me, let me know. So we talked about conservator. And again, for those who just joined, you're going to get these slides. They will be emailed to the email that you registered that you used to register for this program. The next document is called a homestead declaration. This is specifically for people who own real property in Massachusetts. So a homestead declaration protects up to $1 million worth of equity from unsecured creditors in your home. If you own property in Massachusetts and you do not have a homestead declaration, something that you file with the Registry of Deeds, then Massachusetts automatically secures or provides $125,000 worth of protection. But for a $35 filing fee, and it's a form, and this link will take you to exactly where you need to go when you get these slides. For a $35 filing fee, you fill out this form, you record it with the Registry of Deeds, you just upped your $125,000 to $1 million. Oh, I did get a question about the power of attorney form. What if a bank rejects the power of attorney and insists on using their own form? So that can be really specific. We want to make sure that what you need your agent to do is expressly written in the power of attorney document. But I will say some larger institutions wreak a little bit of havoc for estate planning attorneys. There are some larger institutions that make it a little bit harder. They may insist on their own form, but essentially the law is if it is a valid power of attorney, meaning that it is notarized, it says exactly what you need it to say, then they have to abide by it. They have to use their own form. I would talk to an attorney if a bank is giving you an issue with that, but they have to use it. But some larger institutions, this has come up. What most often we've heard of is, well, this power of attorney document's 10 years old. How do I know it's even good anymore? That can sometimes come up. That's why sometimes I'll include a time clause in there saying it's good despite the passage of time. So a number of these things can be kind of corrected in the document. And yes, we have a hand raised. Go ahead.
Yes, sometimes banks, unless the person is like added in the bank account, they don't accept their power of attorneys because it happened to a person that I know that the father was able to claim the balance on his son because his name was on their account or their son. Once the son passed away, has an accident, they say the only way that we give you the money is because you were in the
Right.
account.
Okay.
No, because
I'm
you
gonna-
have a power of attorney.
Yeah, I'm going to interrupt you right there. So the powers of attorney, once the primary person who owns this power of attorney, so if you're drafting one for yourself, and once you pass away, that document is void. It is only a lifetime document. So once somebody has passed away, the bank was right. That person, the agent under the power of attorney, no longer has any authority to access those funds. That authority then transfers to the personal representative, the person who's managing the estate. So that's that situation. I'm glad you brought that up. It is important to know that these lifetime documents, the power of attorney being one, once the person has expired, they have, the document does too. So thank you so much for bringing that up. And then one question here, is a homestead declaration not typically included with a new mortgage? Usually it is. So usually it's just part and parcel with the packet. You just want to make sure that you are filling one out as part of this packet when you buy a new home. But most real estate attorneys, most real estate agents, they know to include this form with them. This is just making sure that you all know to triple check that this is part of that. If you buy a home, go back into the registry of deeds, search it, make sure that you have one for you. And then adding on to the homestead declaration for people who are 62 years of age or older, or who have a disability as defined by the Social Security Administration, each owner can be eligible for up to $1 million worth of protection. And then that means that that home in total will have $2 million worth of protection, but for everybody else, then the home has the protection of $1 million. I have one question here. If someone doesn't have dependents, can you appoint an attorney as a guardian or conservator? Yes, you mean like a professional attorney like me? There are attorneys who will be fiduciary. So all of these agency roles, that's called a fiduciary. There are attorneys who are willing to step in and be a healthcare agent, be an agent of an attorney, be a personal representative. It is a fee though. Once you hire a professional, they are going to ask for a retainer. And then does a person in a power of attorney need to be a Massachusetts resident? So this is a very good question. I have drafted powers of attorney for people who have come into Massachusetts but still are not Massachusetts residents. It gets a little questionable because what we're drafting is governed by the Commonwealth of Massachusetts, making sure that that person is really aware of that, because it may be different from Florida or Vermont or New Hampshire where they're from. The agent in the power of attorney, they don't have to be a Massachusetts resident. They can be anybody. You just want to make sure that you're picking somebody who's actually available in the event that you need them to step in. All right, I'm going to move on to our third financial document. So this document is called a trust. Most people have heard of trusts, but I just want to make sure everybody knows I'm going to do a very high level overview of trusts here. If you think that you need a trust, speak to an attorney. And you're going to want to make sure that you speak to an attorney who specializes in the kind of trust that you need. So a trust, and my wonderful colleague here at the Legal Service Center created this really great analogy. She said a trust is like a ball. But what sport are you playing? Are you playing football? Are you playing baseball? All of these balls look different and all of these rules are different. If you're playing soccer, then you can't touch that ball with your hands. But if you're playing football, everyone's touching that ball with their hands. So a trust is like that. You need to figure out what your purpose is here. So a trust can avoid probate, which is we're going to talk about when we talk about wills. A trust can protect beneficiaries from certain creditors. A trust can make sure that when you're leaving something to someone, that that person can't just turn around and sell it, that it travels down through generations. And so you're kind of like reaching up from the grave to manage that property still. And a trust, and this is what we kind of focus on here at the Legal Service Center, a trust can help people preserve their eligibility for means-tested government benefits. And I'm going to get more into that as we further along in this presentation. So there are probate avoidance trusts, there are tax avoidance trusts, there are special needs trusts for people who have a disability. Trust can do many, many things, but not everybody needs a trust. You may be perfectly fine if you have your full estate plan and it doesn't include a trust. So it is important to talk to an attorney who understands these kinds of things. That's true. Somebody did mention the goalie can touch the soccer ball with their hands. Yes, the goalie can. How to find a capable trust lawyer. So I'm going to get to that question at the very end of the slides. I'm going to have some referrals there for you. All right, so I'll talk a little bit more about different kinds of trusts as we move along. So now we're going to go to our next section, health and medical documents. All right, so the first document most people again have heard of, it's a healthcare proxy. If you've ever done intake or filled out intake paperwork for a hospital or for a new primary care physician that you're seeing, they may have automatically included a one-page healthcare proxy. The healthcare proxy really is just, if we're thinking about the power of attorney document and the healthcare proxy, I want you to think about them as polar opposites of each other in almost every way. So with the power of attorney document, it manages legal and financial decisions. Whatever is listed in there, they can do it. Your agent can do it. With the healthcare proxy, it handles medical decisions only. And unless you limit them in this document, the assumption is they can do everything under the sun. It's why most of the ones from hospitals are just one page, because you just fill it out and then automatically they can make every medical decision you could make for yourself. But Massachusetts allows for limitations. And so you're going to want to speak to your attorney about what your preferences are. If there's certain types of treatment that you know you react poorly to, you're not necessarily allergic to them, that should be in your medical file. That's a whole other thing. But certain types of treatment, if there are specific types of, yes, you're going to get my contact information later. If there are specific types of treatment that may go against your cultural or religious beliefs, you're going to want to create some limitations in your healthcare proxy document. Massachusetts lets you do that with an exception, which we will talk about. But also for the power of attorney, for most of them, the durables, as soon as you sign it, it can be used. For the healthcare proxy, it can only be used, it's only activated when you are incapacitated. And once a doctor decides that you're incapacitated. And again, we're going to use this light switch analogy. A healthcare proxy can be inactive and then you go into surgery and it's activated, it's on. Your healthcare agent is now making decisions for you. Only one person can make decisions for somebody at a time. 99% of the time it's going to be you. You are incapacitated, your healthcare agent's making decisions. You wake up from anesthesia, you're no longer loopy, you're totally fine. Light switches off, healthcare proxy is inactivated. It doesn't mean it's void, it's no good. It just means it's not activated anymore. So you're back to making your own decisions. And again, you can put limitations in there for certain things that you do not want. And we are going to kind of look at the healthcare proxy as in conjunction with this concept of a guardianship. So we talked about this a little bit earlier. The incapacitated person, oh, thank you. Okay, I hope everyone can see in the chat. I'm really happy that Nikki mentioned that there is going to be a healthcare proxy clinic at several of the Boston Public Library branches. My team will be at one of them. A number of really phenomenal estate planning attorneys are going to be all throughout these branches providing healthcare proxies for people. So please click on that link and register. So this concept of a guardianship, again, it's a court-appointed agent. If you have a healthcare proxy and you've assigned a healthcare agent, 9 times out of 10, you're not going to ever need a guardianship. But if you limited them so much where a doctor says, if they don't get this treatment, they're going to die, and the healthcare agent says, I can't do anything about it, they've limited me, there is this option where somebody can try to do an end run around, go to the court, get a court-appointed guardian to make this one specific decision. But if you've limited them for really personal reasons, then it is unlikely that an investigator is going to say, okay, then I demand that you do this. But if it's a little bit vague, then they may appoint somebody. So the guardian, again, a court-appointed person, it's for people who are deemed incapacitated, meaning that they cannot understand or communicate their own decisions. And once again, if you've appointed somebody in your power of attorney, a court agrees that you need someone, then that's the person who's going to be slotted right in. Any questions about a healthcare proxy? All right, I'm going to move right along. So medical directive. A medical directive is tied very close with a healthcare proxy. Sometimes you've heard this document be called a living will or a directive to physicians. It's all the same thing. I call it a medical directive instead of a living will because I think it can get confusing. It's in no way like a regular will. So a medical directive is a document where most often people list their preferences for extreme end-of-life situations. This is guidance for your healthcare agent. You're not naming a new agent in this document. It is guidance for your healthcare agent. And I say guidance because in Massachusetts, this document is not legally binding. So if we have any veterans on the line, you may have filled out the VA form that's called a power of attorney for health and living will. That means healthcare proxy. They just call it the power of attorney for health, which is very confusing. That's why we're talking about state-specific stuff here. And living will, again, a confusing name, but they mean medical directive. Even if you filled that out at the VA, but you are in Massachusetts getting your VA care, that living will becomes not legally binding. That medical directive, it's not legally binding. In other states, it is legally binding, but here it is purely guidance. But we still say it's important for clients to fill out this document, even if it's not legally binding for a few reasons. So one of them is if your agent has to make an end-of-life decision for you, whether or not to remove life-sustaining treatment if you're in a vegetative state, they're going to want that guidance. It is very hard to make that decision for somebody else. And if they see in writing what you would have wanted because you put some thought into it before you were incapacitated, then they're going to feel a lot better. They're going to feel affirmed in making that decision for you. Also, in the event that your healthcare agent who is listening to this guidance is going far afield of what you express in your medical directive, this document says, yeah, Massachusetts is not going to force someone to remove life-sustaining treatment from someone else or keep it on. But this document can be evidence to remove that person altogether from being the one who makes the decision and replace them with your backup healthcare agent or someone else. So it can be used as evidence of what you want in the event that your healthcare agent really is not abiding by your wishes. And you said very clearly, the moment a doctor says that I am brain dead and I am not going to be waking up from this coma and you're keeping me alive for 5 years on life-sustaining treatment, this can be pulled into evidence to remove your healthcare agent. So can't force somebody to make the decision, but it can be used to help replace that person. Any questions about the medical directive? All right. And again, for those who joined, you all will be getting these slides. So I do want to toss in a MOST. So it's a medical order for life-sustaining treatment. In some states, it's called a POST, a physician's order for life-sustaining treatment. It is similar to a medical directive in that most usually cover end-of-life decisions, similar to a do not resuscitate form, a DNR. If you've watched any medical shows, you may have heard of DNR all the time. She signed a DNR. We can't provide any CPR. That's exactly what this is. A MOST is just what it says. It is a medical order. So when people are nearing end of life, if they have a terminal illness and they are going to die imminently, most healthcare facilities or most hospitals, their social workers, their nurse, or their doctors will come up to that person, that patient, and they'll explain the MOST form. And they'll say, do you want to fill this out and provide us with guidance when you get to that point of nearing your passing away, and what you want. If you become incapacitated, if you require CPR, do you want us to just let you pass? Or do you want us to make life take extensive measures to save you and bring you back, even though it's not going to prolong your life for very long because you're still going to pass away from this illness? So this is something that is owned by the hospital. It's filled out in a hospital. Most often your healthcare agent can fill this out for you, but it is a medical order. Once this is filled out and say you sign that DNR, that do not resuscitate, then they have to listen to it. They cannot bring you back. So I do want to compare the two. One is like a legal document. It's guidance for your healthcare agent. In this one, it's a medical order that you are directing your doctor to not bring you back or bring you back, depending on what box you check. and this is not a document that you fill out with a lawyer. This is a document that you fill out with your medical team. I have a question. Can you talk about the role of a spouse in the absence of these documents? Do next of kin have any power under the law in the absence of a named proxy? Yes and no. A horrible lawyer answer of it depends. So oftentimes, if there is no named proxy, a hospital may want to go to next of kin. But if you've named a proxy, a healthcare agent, that is not your spouse, then that's the person that they're talking to. They're talking to your healthcare agent and not your spouse. So I've worked with a number of people who their spouse is not their primary person. They don't want to name them as the primary to make legal decisions or healthcare decisions for them, in which case that is binding. Those other people become your agents. So in that sense, you know, your spouse is not always going to be the default. Say, and we'll get to this when we get to our third section here. But say you've passed away, your body is at the hospital, they're really looking at next of kin. If you have a spouse who's estranged, but you also have an adult child, your family better get that adult child to the hospital right away to claim your body before that spouse. So there are some competing interests there. But it's why we want to make sure that we are very clear about who is making decisions, what are they allowed to make, what are they allowed to do, and when are they allowed to act. Because it's not always next of kin, it's not always a spouse that people automatically want, but the law does assume that. All right, I'm moving on to HIPAA authorization. So this one most people have heard of. It stands for the Health Insurance Portability and Accountability Act, HIPAA, 1P, 2 A's. This one is an authorization where once you fill it out, you can name somebody in the HIPAA authorization saying, I authorize this person to speak to my doctors, access my medical records, and gather all the information they need. If somebody's acting as your healthcare agent, their authority, once it's active, to speak to your doctors, access your medical information, it's implicit in the law. It's implicit in the general laws, but we'll often say that if you want to give somebody a HIPAA authorization, fill out a separate HIPAA authorization. And if you want to make sure that they can still access, your medical records after you've passed, then you're going to want to fill out a separate HIPAA authorization for them that makes it very clear that this continues even after I've passed with no expiration date. Otherwise, again, the healthcare proxy, it's only good while you're alive. Once you've passed away, it's a voided document. I've had clients who never wanted to fill these out. I heard clients who said, I'm going to fill it out for almost everybody I know. So it really is just dependent on your situation. But think about if this is something that you want to fill out. If you do you want to give it to them right away? That kind of thing. But I will say, HIPAA authorization aside, where it is case dependent, make sure you give your medical documents to the hospitals. You want to make sure that they're actively reaching out to the right people. If you filled out a healthcare proxy form for them, until you give them a new one, they're going to go buy the old one. And once you give them the one that you drafted with the lawyer, if you ever seek medical care from anywhere else, once you fill out a new one, it voids the one that you filled out with the lawyer. So if you're going to go see a new doctor or a new team, bring a copy of your healthcare proxy with you, send it to them through the portal. If you have an online portal, get it to them in any way that you can, or just say, I'm not filling out a new healthcare proxy. I have one at home, so I'm just going to bring that later on. Or I've had a client who said, I don't know anybody I trust enough to name as my agent, so I'm just not filling out a healthcare proxy ever. And that was a decision that that client made. When that client needed surgery, they tried to withhold treatment and say, you must fill this out. Otherwise, we cannot give you the surgery. Nope, it's unlawful. It is very clear in the statute. And we needed to remind them of that they cannot force you to fill out a healthcare proxy form and withhold treatment. They have to give you treatment, and you do not have to have a healthcare proxy form. So because that happened, and I was a little bit shocked that they were so aggressive about it, I like to say it in these webinars to remind everybody. All right, so we're going to move on from lifetime documents. Any final questions? Someone suggests I bring a package of these documents with me wherever I go to the ER. I love that person for you. I think that that's a great suggestion. Yes, everyone should do that. Okay, now we're going to talk about preparing for death. So probate, I mentioned this a little bit earlier in the presentation, but it is a concept I want to cover a bit more fully here. So usually when I explain probate, I explain it in the opposite. I talk about non-probate. One second here. So most people are they're aware of things like life insurance policies, that you have a life insurance policy. It could be $10,000, like a burial policy. Some policies could be $500,000, and that's on your life. When you pass away, then the named beneficiaries that you've written in that policy then get the payout of that policy. So this concept of like this life insurance policy where you've named a specific person to take that asset, that amount of money, upon your passing, this specific event, the event being your passing, that makes this asset non-probate. Where it goes lives in a separate document. It lives in this contract. If you own a home as tenants by the entirety because you own it with somebody that you are married to, or joint tenants with rights of survivorship, which have rights of survivorship, then that means that when one of you passes, the other one automatically owns 100% of the home, and that home does not fall into probate. That's non-probate. If you have a 401k or a retirement plan, and you list a transfer on death beneficiary, and again, it's transfer on death, not payable on death, because the age of that person matters when you're thinking about tax implications and required minimums. I'm not going to get into it. But if you've listed that person, then that account does not fall into probate. It goes by virtue of that will. So when we think about probate, we're thinking this is everything else. This is everything that does not have a designated beneficiary of some kind. I would say the one exception where you don't have to expressly designate a beneficiary is a vehicle. In Massachusetts, if you are married and you have a vehicle only in your name, the Registry of Motor Vehicles here, the RMV, allows you to fill out a form. It's online, a survivorship form, where you prove that your spouse has passed away, and then they transfer the title into your name. So that's one minor exception. So probate is everything else, and this is where the will comes in. Even if you've named non-probate everything, and you've done a probate avoidance trust, you still need a will. Everybody needs a will, because you want to make sure that you are catching anything that you might have forgotten, anything that falls in there. And at the end of the day, when you've passed away, there may be nothing in probate, in which case, great. But if there is, then you've named exactly who's managing it, where is it going, and you've laid out all the rules in the will, and the law is not determining what happens to that piece of property. So everyone needs a will. A question has come in: what if I die while writing the will before it becomes valid? That's intestacy. So I'll talk about that. So I'm going to move on to will, but let's talk about this concept of intestacy. So if you pass away without a will, and you have something that falls into probate, you've died intestate. I don't know why they came up with this term. It's not very helpful, but you have died intestate. And so the law determines who gets your property. I'm going to use myself as an example. I often do. So I am married. And in the state of Massachusetts, most might assume that when I pass away, everything goes to my spouse. But my spouse and I do not currently have children, legal or through adopted, no biological children. We do not have children, which means that in Massachusetts, if I pass away without a will, my spouse shares my estate with my parents who are living. That's the way intestate will work. As soon as my spouse and I have children or have a child, my parents, they're tossed aside, and Massachusetts says, okay, now you have a spouse, that's great, and you have children, wonderful, everything 100% to your spouse, but nothing to those children, nothing to that child. This is not always the way that people think that that their remains are going to go, that their estate is going to go, and it's why a will is so important. At a certain period of life, I've had a number of clients who come in and they say, I have a closer relationship with my adult children than my spouse. I want to make sure that they get things. All right, great. Then let's do this. Let's make sure that they take some of your property, because intestate, they get nothing. If you have a spouse and you have children with that spouse, but you also have children outside of that marriage from a prior relationship, those children take along with that spouse. But any children that you have with that spouse they still don't get anything. And testate rules can be somewhat nonsensical and a little bit confusing. So that's why we write wills. We want to make sure that everything is exactly as you want it to be, that it covers your probate assets, that it's a nice backup in case any of your non-probate designations fail for some reason. Someone passed away before you, or the form was filled out wrong and it falls into probate. It doesn't always fall into probate. You have to read those contracts. Sometimes those go to next of kin. But if for any reason they fail, they fall into probate, you want to make sure you have your will that's set up as a nice backup. The agent in your will. So we keep talking about the agents that you assign. This one's called a personal representative. They used to be called an executor or an executrix. No longer in Massachusetts. We have adopted the Uniform Probate Code, and it is now called the personal representative. And the person who passes away is called the testator. So if you are filling out a will, you are the testator. Any questions about a will? Okay. So again, it's where you designate where your non-probate assets go. You name a personal representative to manage and follow the instructions in your will, distribute these. It's important for people to know you can disinherit children in Massachusetts. You cannot disinherit spouses in Massachusetts, not fully, and the rules are a little tricky. So talk to an attorney if you want to make sure that your spouse doesn't get everything. There are some ways here and there where you can provide some protections. I have a question. What about writing a will that says that I leave stuff to the state of Massachusetts? Yeah, you can do that. You can leave things to charities. You can leave things, things to really anybody. I do want to make sure that people know in the state of Massachusetts, pets are considered tangible property. Pets are akin to like a car or a book or a piece of clothing. It's sad, but you can't leave something directly to a pet. You can leave something for the care of a pet. A wife can change a husband's will. No, you are only responsible for your own will, and no one else can draft or change your will. There are a lot of protections around how a document like a will is executed or signed. And if those falter in any way, then that will may be deemed void or just not valid. No one else can change your document. What steps should you first take in order to create a will? Talk to an attorney, an estate planning attorney. Can personal representatives be a beneficiary under the will? Great question. Yes, they can. All right, I'm going to move on to the next document. This is called a declaration as to remains. So not everyone is aware that this is a kind of document that you can fill out. It is something that can be a section of your will. So, but because a will is a public document, meaning if you go to a probate court and you ask the clerk's office and you know the names, they may, may be able to find somebody's will. Sometimes we fill this out, this declaration as to remains that covers what you want to have happen to your remains after you've passed. We stick this in a separate document. We name a different agent, we stick it in a separate document, and then the will may just reference and say, I've left this other document, go see that, instead of putting all the details in your will. Quick question, does any attorney do free consultation for talking about a will? Some attorneys might do a free consultation. I am unaware who does, who doesn't, but I'll send you the referrals, and that's a question that you can ask when you get them on the phone. So declaration as to remains, here you can list out, do you want to be cremated? Do you want to be buried? Do you want to be put in a salt urn and in the ocean? Do you want to make sure that you have a celebration of life that has nothing to do with any kind of religious tradition? Do you want to have a priest? What do you want to have happen to your remains? And importantly, again, who do you want to control your remains? What agent are you naming in this document? So work with an attorney to kind of fill this out. If you want to have your ashes scattered in the ocean, there are environmental laws. Your attorney is going to know to look those up and guide you and make sure that what you're asking for is not illegal or unlawful. But we'll make sure that we fill out this document to the best of our abilities and make it very clear and walk you through the various costs that might be associated with some of this and where you want those costs to come from. Any questions about any of the documents? Okay. So why is estate planning important? Hope you know for a number of reasons now. So then in the event of your passing, the state law without a will or a probate avoidance kind of trust, the state law is going to determine who inherits your property at your death, and it's not always who you want it to be. The probate court can't appoint somebody to manage the distribution of that property. They're going to appoint the PR, and family might have some conflicts here. So people come out of the work, they might try to claim some things. But if you've laid it out very clearly and succinctly, then it should be a relatively smooth process. And there are different types of probate. Probate does not always mean going before a judge and there's a trial. There's something called a voluntary administration if you have a very small estate. There's something called informal probate as well, kind of meeting in the middle. So there are a lot of options, and it's good to know that you've planned in advance for exactly what you want to have happen, and who you want to control. And then again, in the event of incapacity, you are unable to speak for yourself, you're unable to understand questions being asked of you, a probate court might step in and appoint a guardian or a conservator. You might not want those people. You want to make sure that your lifetime wishes are followed. And so you write those lifetime wishes down, you appoint the right people, you give them access to what they need access to at the time that they need it, and then everything again should run very smoothly. But an estate plan gives you back control and autonomy of your decisions in the event that you have passed away, or when you have passed away, or in the event that you are incapacitated. It helps you prepare for crisis. Sometimes it can help you avoid probate. I've helped people avoid probate without ever touching a trust, just by using all of these other mechanisms. It could qualify you for government benefits. It could give you some peace of mind. Question came in, can I put someone who is outside of the US in my will? Yes, you can. So who needs estate planning? Everybody needs estate planning. That's why this program is called Estate Planning for All. If you are over 18, you need estate planning. But especially if you are at risk of a medical crisis, incapacity, or passing away soon, you've been given a diagnosis, and maybe, there are certain types of cancers now that are more seen as chronic illnesses and terminal illnesses, but it's good to plan. Make sure that you're planning ahead while you have the time to think it through. I've drafted estate plans for people who maybe had a week left to live and they feel rushed. There's an urgency there, and it's a situation that you never want to see anybody in. You want to think through your options, think through your plans, give yourself the time that you need. These are big decisions. And then also people who are receiving means tested benefits. So I said I was going to come back to this. Here we go. And again, everyone's going to get these slides. You can click on these links. So an example of means tested benefits is something like SSI, Supplemental Security Income. This is a federal program, not Massachusetts specific. This is from the Social Security Administration. So here, in order to qualify to receive SSI, Supplemental Security Income, you need to be living in near poverty. You need to have no more than $2,000 at the end of every month in your assets, so like in your bank account, liquid assets, cash, and you need to have an income of no more than $2,000 coming in every month. In the Boston and Cambridge area, it's near impossible to live on that amount of money, but that's what SSI is. But say you come into an inheritance, but you're on SSI and your inheritance is $100,000. That's incredible. That's life-changing money, but it may not mean that you never need SSI again. You're on SSI because you're living in poverty and also because you have a disability in order to qualify for SSI. This life-changing money may be something that you can finally pay for care for your pet, which SSI doesn't cover. You can pay for gas for your car, which SSI doesn't cover. You can pay for a number of things, but it is enough to penalize you or kick you off of the program, but it may not be enough where you never need that program again. So there are tools like a special needs or supplemental needs trust. Again, this is one sport. This is one kind of trust. Some of these trusts need to be established before the age of 65. You want to make sure that you're talking to an attorney who specializes in working with people who have a named disability by the Social Security Administration. Another way is if you have your disability before the age of 26, an ABLE account may be an option for you. It's like a debit card where that money goes into the ABLE account and then the person with a disability can use it. That link works. I highly recommend clicking on it. There's a ton of information there. And ABLE stands for Achieving a Better Life Experience. As of January 1st, 2026, So we're a little less than a year away from it. There was an Able Age Adjustment Act, which increased this age from 26 to 49. So in January, the age will be if you've had your disability by the time you're 49 instead of by the time you're 26. I have a question here. Okay, great. Thank you. Everyone see the chat. Nikki posted some resources in the chat. Thank you so much, Nikki. And then another, this is Massachusetts specific, Mass Health. So every state has their own Medicaid program. Our Medicaid program in Massachusetts is called Mass Health. There are some Mass Health plans that have that same means tested benefits, but there is something called a state recovery and in almost every single state, but especially in Massachusetts. And this is where one example, you need long-term care. You need 24-hour nursing home care. You're older or you've come across a chronic illness where you need this level of care and you need access to nurses for this long-term period of time, but you can't pay for it. Nursing homes cost hundreds of dollars a day. Mass Health says, don't worry about it. Just spend down all your assets. So you're at that 2000 mark. Strangely enough, it's exactly the same as SSI requirements. And if you own a home, that's fine. Totally fine if you own a home. We're not going to count that against you as long as it's not in some sort of other trust. But what we're going to do is we are going to, Medicaid is a federally funded program, but every state can choose whether or not they want to reach the ceiling of what they're allowed to do. So Massachusetts is Mass Health. Their rules are slightly different than other states. But yes, it is a federally funded program, but it doesn't mean that the rules are all the same across the states. Medicare might be the one that you might be thinking about. That is federally funded. The rules are the same across the states. So here, Mass Health is saying, yes, we'll cover it as long as you spend down your money so that you have this amount. You have to show us that you spent it down in a way that's allowable by us. It's not just to preserve eligibility. And we're going to look back at the last 5 years of your finances to see what you've spent it down on, to make sure that you're not just giving away thousands of dollars of gifts to your grandkids, because that doesn't count for us. You need to spend it down in a proper way. But we're also going to place a lien on your home. And if you sell it during your lifetime, we want to get paid back for every dime we put into your care. I'm overly simplifying this program. If you think that you're going to need long-term care covered by Mass Health, by our Medicaid program, speak to a Medicaid planning attorney. Again, each attorney kind of specializes in their own thing. A Medicaid planning attorney may also be a tax attorney, who may also be an attorney who works with people with disabilities. But it's not always true. So you want to make sure you're speaking to the right people, because there is something called a Medicaid planning trust that can help preserve your assets in your house from this kind of lien. But you need to make sure that you understand the components of this, the really specific rules behind it, and other ways of maybe avoiding some of these liens, or knowing the exceptions to this 5-year look back period. So doing estate planning includes doing this kind of long-term life planning. You want to know what your plan is for if you become incapacitated, not just who's going to step in and make decisions, but what's going to happen to you. What's going to happen to you if you need to go into a nursing home? Are you prepared for that? Is your estate prepared for that? You want to make sure that you're talking to the right attorney, and any attorney who speaks to you worth their weight in salt is going to ask you, what government benefits are you currently receiving? And they're going to ask you some probing questions that might seem a little bit intimate, but it's to determine what you might be eligible for in the future. And if you are leaving any money to anybody who might also be receiving government benefits. Most clients do not want to leave enough cash to somebody that's then going to kick those people off of their benefits. So most attorneys are going to come with a big questionnaire. They're going to have a ton of questions, and it's to get at all of this so they have a very full picture and they can properly advise you. And the next one, it is important for the veterans to know, there is a means tested program called the VA pension. It is not retirement. It doesn't mean you've served in the military for 20 years. This is VA pension. It's means tested. This one, unlike the other programs I've mentioned, it actually increases every year. So if you click on this link, you'll see the 2025 rates, and they're looking at net worth, so assets plus annual income. If you come into an inheritance, sometimes you can put it into something called the VA Pension Planning Trust, but this is just something I want to make sure that veterans understand. This is one of the programs that is means tested for veterans. Any questions right now? What is a lien? So a lien is like secured debt. So if you have a mortgage, you don't, you don't 100% owe your home. Somebody's saying, if you ever sell this, then you have to pay me back. You have to pay the debt either from the proceeds of that sale or through some other means. So they're placing a lien on property to say, if you sell that property, I get paid back first. All right, summary of documents. So today we talked about the power of attorney, homestead declaration, a trust, healthcare proxy, medical directive, HIPAA authorization, the witness declaration as to remains. And again, you're all going to get these slides. Here is a list of where you can find access to attorneys. I highly recommend the National Academy of Elder Law Attorneys. Massachusetts has a very robust chapter of this national program. And these attorneys rely on each other often when complicated questions come up. So not to confuse you, but I'd start from the bottom up. Those attorneys are fantastic. Any last questions for me? All right. So I'm in the first two, LSC, Veterans Legal Services, or sorry, Veterans Legal Clinic. Veterans Legal Services is a different organization. Veterans Legal Clinic. Okay. No questions. Nika, I think we can stop the recording.